The initial letter to the doctor is usually called the Rule 4 letter, and it's at that stage that the General Medical Council will notify the doctor that a complaint has been made against them. At that stage, there's usually very little evidence provided to the doctor because the GMC hasn't done any investigation. There are some circumstances where you will get some documentation, for example, if it was based on a criminal conviction that's already been concluded, or for example, an insurance fraud where the company has already provided all of the documents to the doctor. It's always beneficial to the doctor to get legal advice at that stage, just so they can talk through the process and be calmed about what may happen at the next stages, and that's where we can assist. A lot of doctors come to us asking us about circumstances when they need to make a referral, and in short, in accordance with good medical practice, there are obligations to make a referral to the General Medical Council yourself, usually where you've received a caution or conviction, whether that be in the UK or elsewhere, and if it's elsewhere, it would be in relation to something that would be considered a crime in the UK. If you have been criticised by an inquiry, for example, an inquest, and some adverse comments have been made about you during the course of that inquest, where there has been a situation where you've been arrested and or charged, so even before it gets to the point of being a full criminal charge. And also there are circumstances where you've had an internal investigation at a workplace and that has resulted in some type of action against you. Equally, good medical practice asks you to be candid and make a referral in those circumstances. During the course of the investigation, so this is before it's been concluded, there can be a referral to the Interim Orders Tribunal, and that tribunal does not make any determination about the facts, and clients often get very confused about that. They are only there to consider whether in the interim, whilst the investigation is ongoing, whether the doctor's practice should be restricted. Now, they can impose an interim order of conditions or an interim period of suspension. As the name suggests, suspension means that you cannot practice. Interim orders are reviewed every 6 months. They can be varied and they can be revoked. They can also be varied in a way that means it bumps up to be becoming more serious. So an interim order for conditions can become an interim order for suspension if more issues have come to light. One of the issues that clients always raise with us is how long is this investigation going to take? And unfortunately, we usually have to say that it can take a considerable amount of time. Depending on the nature of the allegation, for example, if it's a health case, the GMC will ask the doctor to attend a health assessment with medical examiners who have been appointed by the General Medical Council in order to do a full and independent assessment of their health and provide a report. In misconduct cases, for example, that can include witness statements from any key witnesses, also from the complainant, also from anyone at their workplace, etc., that may have been witnesses to the events. In relation to lack of competence cases where there's issues about the doctor's knowledge and skill, there can also be a performance assessment, and that is independent. It is carried out by a number of independent assessors who are appointed by the General Medical Council, and it is also a simulated assessment of the doctor's skills. There will come a stage where the Assistant Registrar will write to the doctor with the Rule 7 letter. That Rule 7 letter encloses the draft charge, and it also encloses the documentation. At that stage, if the doctor hasn't done so before, it is important that they get independent legal advice, because that is the stage where the complaint will basically be determined by the case examiners. The case examiners can do a number of things in relation to the complaint. They can decide to close it with no further action, which means there is nothing ongoing. They can issue a letter of advice. A letter of advice is not public, but it does advise the doctor as to their future practice or their future conduct. They can then give a warning, and a warning is ordinarily public, and equally like the letter of advice, it gives them a warning as to how they should conduct themselves in future. Then the doctor can decide to enter voluntarily into undertakings. Undertakings are usually used in cases where knowledge and skill is an issue, and undertakings can be things such as you must produce a personal development plan, you must work alongside an independent tutorial assessor, and such likes. If none of those are considered sufficient and the case is serious, then it can be referred for a full fitness to practice hearing before the Medical Practitioners Tribunal Service. If the matter proceeds all the way to a hearing before the Medical Practitioners Tribunal Service, there are a number of stages to that hearing. So the first stage is the factual stage, and it's at that stage that the panel decides whether or not the facts which are alleged have been found proven. Very often clients make admissions, and that stage can be dispensed of quite easily. The next stage is the statutory ground stage, and that is when the panel decides whether the facts that have been found proven, do they fall far enough below the standard expected of the doctor such that they amount to misconduct or deficient professional performance. The next stage is the impairment stage. Now, very often by the time you get to a hearing, the matters have occurred some considerable time in the past, but they are considering impairment at the current day, so the day that they are making that decision. And the key factors that they look at, for example, are: has the doctor's actions brought the profession into disrepute? Do they potentially undermine public confidence in the profession? Or does the doctor present a risk to patients? If that stage is also found proven, you then move on to the sanction stage, which is the one that clients are most worried about. And that is the time when the panel can impose a sanction. So they can impose conditions, they can impose a suspension order, or they can strike the doctor from the register. Once the decision at the sanction stage is announced, ordinarily it comes into effect 28 days after the hearing. That is, unless the GMC case presenter asks for an interim order. So very much like the interim orders we discussed at the beginning, that restricts the doctor's practice in the interim until the sanction comes into effect. And the appeal period is also that period, so it's a 28-day period. So much like the interim orders tribunal, the panel there have the same powers. They can impose an interim order for conditions or an interim order for suspension. Now, that appeal period is very important because if the doctor does intend to appeal the sanction that has been imposed against them or any other stage of the process, they have to use that time in order to do so. The court waive the appeal times in very, very limited circumstances. So if the doctor at that stage hasn't had legal advice, or even if they have and they want to appeal, it is very important that they do work with lawyers such as ourselves in Kingsley Napley in order to lodge that appeal.